Good afternoon, everyone. Welcome to our HHQ webinar. We are glad to have many attendees with us today for our webinar on effective dispute resolution in the construction sector with insights on CIPAA 2012. Before we kickstart this session, please be informed that all participants will be muted, and if there are any questions, please type in the chat box and we will discuss them during the Q&A session later. Please scan the QR code appeared on your screen for attendance purpose. Allow me to introduce our speaker today, Mr. Ankit Sangvi. Mr. Ankit currently is the Principal Associate of Halim Hong & Quek. He has represented a number of multinational and government-linked companies in Malaysia, both in an advisory capacity as well as lead counsel at all levels of the Malaysian courts. He has been involved in numerous legal disputes concerning land law and has acted for various developers and banking institutions on a variety of claims, including claims for liquidated damages, specific performance, and prohibitory injunctions. So please join me to welcome our speaker, Mr. Ankit.
Thank you, Hilary, for that very kind introduction. And a very good evening to all of you tuning in this evening. It's morning over here for me. And if you all have scanned all of your respective QR codes, I shall proceed with the session for today. Let me just... Yeah. So without further ado, let me begin with a few words introducing the topic of CIPAA. Now, CIPAA is, of course, as all of you would know, it's called the Construction Industry Payment and Adjudication Act. And the act it was passed in the year 2012, but it had only come into effect in the year 2014. So there was a sort of a 2-year period for which the act had already been passed by Parliament, but it had not come into force yet. So currently, since CIPAA has come into force, we have had about 7 years of the workings of statutory adjudication in Malaysia. Now, as you all would know and would be able to appreciate, the construction industry is of course facilitated by various dispute resolution methods. Yep. So, of course, construction itself by its nature is very complex. It involves relatively long project durations and is also subject to many uncertainties. So as a result of that, there are various types of disputes that can occur during a project cycle. And these disputes range from a whole host of things. It could be in respect of project delays, design errors, which of course then lead to the request for additional payments, low contractor quality in regards to workmanship, and various other types of disputes. Now, payment in particular is said to be the lifeblood of the construction industry. And when I say lifeblood over here, what I want to emphasize is the fact that the construction industry would completely fail if payment wasn't fluid, or if cash flow was something that could easily get stuck because one party chooses not to pay or delays payment from from main contractor to the subcontractor, or from the employer directly to the main con. There are often delays in regards to payments, and this could actually be a stumbling block for the entire construction project itself. Now, it has often been said that payment is the main subject matter of construction disputes. And of course, it results in project delays, reduced profitability, and abandoned projects. So payment problems are still, until now, the main issue in the construction industry. And in particular, the type of payment issues that we often see is payments from, as I've mentioned, client to the main contractor, either in the form of advance payments, progress payments, or even sometimes final payments, where one party chooses to withhold payment and then a dispute arises. So what happened then was, before I move into that, as I have mentioned, the construction industry is facilitated by few types of dispute resolution methods as a platform to help resolve these disputes. So we have litigation, which is the standard go to court and file your action against the party who you wish to take the action on. Or there's alternative dispute resolution, which means I do not want to go to the courts. I want to have an alternative way of resolving this dispute. Now, in Malaysia, the most common methods of resolving disputes are mediation, adjudication, and arbitration. This session, of course, is going to be focused primarily on adjudication because we now have a statutory adjudication in Malaysia by virtue of the introduction of the Construction Industry and Payment and Adjudication Act. Now, these forms of alternative dispute resolution, be it mediation, arbitration, or adjudication, which is what I'll be focusing on, is actually aimed to achieve resolutions to any dispute in a shorter time span, with, of course, lesser money spent for both parties who are involved in the dispute. And the ultimate aim is to ensure that there is a sort of an independent third party who is resolving this dispute for the parties instead of going through the conventional route of the courts. So there is no court intervention unless, of course, there is later on an application to set aside an adjudication or an arbitration award. It's not easy to do that. So essentially, this gives finality to your dispute, and it's resolved in a much shorter time than what possibly a court proceeding could take and entail. And furthermore, of course, a court proceeding would be subject to various levels of appeals, whereas an adjudication or an arbitration would end over there, meaning once the adjudication is decided and an award is delivered, the award would be deemed as final and binding. But of course, there is an exception to this, which means under certain circumstances, you can apply to set aside the arbitration award, but this is not an easy task to achieve. Now, sorry. Yeah. So as I've just introduced why the construction industry payment, or sorry, why the construction industry is so laden with payment issues, uh, we had in the year 2012 come up with the CIPAA Act specifically to do certain things. So this is just an overview of the act itself. I think what's important for everyone here to know is that CIPAA is, of course, a statutory form of adjudication. Yeah. So if you see the first point that I've noted, it is a purely statutory scheme, and it operates as a statutory scheme alongside any contractual dispute resolution processes provided in the contract that the parties have signed upon. Now, what this means is you cannot have a, for example, you cannot have a contract between party A and party B, which says that in the event of a dispute between the parties, the matter shall be resolved through an internal dispute mechanism system where you bring it up to the CEO level for a resolution or for negotiation with the other side. You may have all of that in your contract. You may even have an additional clause saying that this particular contract is not to be subjected to the Construction Industry Payment and Adjudication Act, and it will not be valid because CIPAA is a statute, and therefore, even if you were to state something in your contract to say CIPAA is not to apply to this contract, it would be a redundant clause because it is a mandatory nature, because it is an act which has been passed by Parliament. As long as you meet the requirements of a construction contract, any party who chooses to pursue an adjudication will be allowed to do so under the CIPAA Act 2012. So please remember this, there's no provision or there's no mechanism which allows you to exclude yourself from the application of the Construction Industry Payment and Adjudication Act. So CIPAA, as you have seen on the right side of the screen, was gazetted on the 22nd of June 2012. It had only come into force in 2014, but in between that, sometime in April 2013, Malaysia had decided to cater for two specialist courts, actually, two specialist construction courts, one in Kuala Lumpur and one in Shah Alam, and they were actually designed to specifically hear disputes or other construction-related disputes. So if you were to file a legal action in court, you will have a slightly more skilled judge in relation to the nature of construction disputes and how it works. And of course, if you were to go through the alternative dispute resolution mechanism, which is by way of pursuing an adjudication or an arbitration claim, and later on one of the parties decides to apply to set aside the award, you would have to again go to the High Court, and you would probably land up in one of these two specialist construction courts, be it the Kuala Lumpur or the Shah Alam High Court. Now, the main aims of the Act were several, but I think the most important one is the first three. Yep, the first one being that it is to provide for a speedy dispute resolution mechanism. Yep, when I say speedy, you will understand this as I come along. The whole process of adjudication is actually very quick compared to court process. And it is also to facilitate regular and timely payment. Now, this is key because when Parliament passed this act, this is what they had focused on, to state that if we don't have something like CIPAA, then by the time a dispute is resolved in court or arbitration, it might take years, and it's going to cause a complete standstill in the project because one party is not being paid. He doesn't want to proceed with the project. It may be the contractor not being paid by the employer, for example. And if you were to go for an arbitration or a litigation, you're going to land yourself up at least 2 or 3 years down the road for that particular dispute to be decided, because there again, there's the High Court. If someone takes it up on appeal, it goes to the Court of Appeal and then the Federal Court. So what CIPAA did, or one of its main aim, was to suggest that there will be a much shorter time frame for these disputes to be decided upon. This means that a party who has not been paid, or rather the unpaid party, that's what we call it, he's allowed to pursue an adjudication claim, and within a very short amount of period of time, he would actually have a decision. Of course, the decision could be against him, but what's important here is that he ultimately has an outcome within a shorter period of time as opposed to taking the conventional routes. Now, it's to provide a mechanism for speedy dispute resolution, and it's also to provide remedies for the recovery of payment in the construction industry. This goes back to the initial slides where I have emphasized that it is payment is the key feature of the construction industry payment and adjudication act, and it is to ensure that there is no hindrance to cash flow, and there are no cash flow problems that exist in the industry, and that in the event there are disputes in relation to payment, then they are easily and very quickly resolvable through the statutory adjudication scheme under CIPAA 2012. Now, this, of course, is not something new. Across the world, we have followed this, or rather CIPAA doesn't just exist in Malaysia, but statutory adjudication also exists in various other places like the UK, Australia, and also New Zealand and Singapore. So we are not the only ones who have statutory adjudication, but I would say that we are one of the first few countries to actually implement the system into the country. As you can see, it's only there are only about 5 or 6 actual countries who have introduced this. Now, the primary objective of the Act, on your left side of the screen, you would see, I have already said that, so I will not deal with it. But the second point below to address cash flow problems, yeah, it's to prohibit the practice of conditional payments, which is pay when paid or pay if paid clauses. And this, as you would know, some of you may know, in the early 90s, in the early 2000s, before the CIPAA Act had come about, it was very common for pay when paid or pay if paid clauses to be inserted in a contract between the main contractor and the subcontractor. And essentially what it states is that you, Mr. Subcontractor, will only get paid if I get paid by the employer. So that is what the main contractor is telling the subcontractor through the contract. And this, of course, seems to be unfair because sometimes the subcontractor has already carried out works. He's issued his invoice or for his progress payment, and the main contractor hides behind this particular clause in the contract to say that, look, there is a pay when paid clause here. I have not been paid by the employer, therefore I can't pay you. Now, this was very common, and it resulted in very serious problems in the construction industry because, again, what happens when something like that occurs is that there is a complete standstill to the project because the subcontractor cannot carry on works because he's out of pocket, he's run out of money, and he cannot continue the next steps until and unless the payments or the previous payments for work done is actually settled. So uh, the primary objectives of the Act, apart from what I've just mentioned, is also to ensure that there is finality through the adjudication award. So if you see the 3 bullet points on the right side of your screen, I'll just go through that. Parties still need to comply with the adjudication decision and pay the disputed amount unless the decision is stayed through an application made to the High Court under Section 16. What this means is that once an adjudication award is delivered, the party whom the award is made against will have no choice but to actually comply with the award. He has to comply with the award, unless, of course, he applies to the High Court to stay the adjudication award. Then he will not need to comply with the adjudication award. Or he applies to the High Court to set aside the adjudication award. But if he doesn't do either of these things, then the adjudication award would be binding. And I also need to emphasize this: adjudication is something that is considered to be, or rather often referred to as rough justice, because it is decided in such a quick span of time. The courts call this an interim, or rather our Malaysian system or courts have recognized this to be an interim settlement of a dispute. What this means is, once the adjudication award has been delivered, you are still allowed to retry this particular facts through a separate court litigation or through a separate court arbitration. But until and unless that is done, and until and unless the award is finally set aside by the High Court, the award remains to be binding. Now, the default function of the CIPAA adjudication regime is, of course, to determine the value of a payment dispute arising under a construction contract. So that is the primary role of the adjudicator, which is essentially to look through documents and to decide, firstly, whether there is any payment that is due. And if there is payment due, then how much is due from one party to the other. Now, what is important to note over here is that there is this particular provision under the Act, which is Section 27, subsection 2, and it states that the parties can actually agree in writing to extend the adjudicator's jurisdiction to decide on disputes concerning matters that are unrelated to payment or outside the scope of CIPAA. So this is very important because people commonly get the misconception that CIPAA is only to decide on payment disputes and nothing else. But that's actually not entirely true, because Section 27, subsection 2 states that parties can actually expand the jurisdiction of the adjudicator if they want to, or if they agree in writing to it. Then the adjudicator may actually even decide on other matters that go beyond payment-related issues. And what this actually means is that CIPAA can actually function as a fully fledged dispute resolution scheme covering all types of disputes, provided that it is agreed by parties. So it is similar to court or arbitration, or rather it can be similar to court or arbitration if parties choose to have the dispute decided in that particular manner, or rather to give the adjudicator such powers to decide on matters that go beyond just payment-related disputes. It could even be disputes such as workmanship qualities and so on. Now, I'll move on to the next part, which is in relation to what is the scope of CIPAA and how does the application of CIPAA work in Malaysia? Now, Section 2 of CIPAA states that the Act is going to apply or will apply to every construction contract made in writing for construction works and or construction consultancy works carried out either wholly or even partly in Malaysia. So you can see this, the way it has been worded, a lot of things actually now start qualifying as a construction contract or a construction consultancy contract. And provided that the work is carried out either wholly in Malaysia or even if it's partly in Malaysia, you would be able to actually pursue a CIPAA adjudication. But what is important over here is that it must be made, the contract must be a contract made in writing. and if it is made in writing and it is a contract that is carried out wholly or partly in Malaysia, then CIPAA would apply. I have not actually quoted this section, but there is a section 3 which states when would CIPAA not apply. So I've not covered this over here, but let me just say this out aloud. CIPAA will not apply if, for example, you are dealing with a construction contract, which is in regards to an ordinary lay person, which means an individual like me and you. So it is more for commercial reasons that CIPAA has been created. And CIPAA would also not apply if, for example, it is in regards to a building that is less than 4-story tall. Yep. So it is actually for commercial and much larger construction projects. So if you are building a 2 or 3-story house and you land into a dispute with your contractor, you will not be able to actually mount a CIPAA adjudication. It specifically qualifies that you have to be, you cannot be an ordinary person, and it must not involve properties which are less than 4 stories high. So now section 4 of the act has actually stated that construction works includes many things. Yeah, it includes construction, extension, installation, repair, maintenance, removal, renovation, alteration, dismantling, demolition, and a whole lot of other things, as you have seen in the section. All of this actually falls under construction works. So basically almost anything and everything that is construction related uh, could actually be subjected to a CIPAA adjudication. I have quoted one case over here, which is a 2018 decision of the High Court in MIR Wolf, Sindran Berhad, and TH Heavy Engineering, Sindran Berhad. And in this case, what they held was that even the supply of valves for installation onto a floating production storage was considered to be construction works for the purposes of the project. And as a result, they could proceed with the CIPAA adjudication as they considered the supply of valves to fall under a particular type of construction work as it involves supply of a product. Now, the High Court decision of Martego, on the other hand, against architect Mio and Chu Sindran Berhad, states that even a construction consultancy contract includes contracts which provide purely consultancy services such as architecture. So even architecture would fall under the definition of a construction consultancy contract, which means that even an architect would be allowed to bring disputes under CIPAA adjudication. The decision of Martego and architect Mio, of course, went all the way up to the federal court. I will deal with this decision a little bit later because that's another point to come to. Now, if you remember again, section 2 states that the construction contract must be in writing. Now, what does it actually mean when it says must be in writing? They didn't define what is writing, but of course, one would think, does writing actually mean that the contract must be signed? Does it mean that it actually has to be handwritten? What does the construction contract made in writing actually mean? Since the Act was silent on it, the KLRCA, or the AIAC as it has been renamed right now, had issued a circular. It's called the CIPAA Circular 03. And what was stated there, what was stated in the circular is that a construction contract is made in writing, whether or not it is signed by parties or made by an exchange of communications in writing or evidenced in writing. So essentially, a lot of things can fall under a construction contract made in writing. Even if I were to email you a document and you then acknowledge to say, yes, this document is accepted, it would be an accepted construction contract, although it has got no signature on it, because there is exchange of communicators already showing that there is intention that parties have contracted to the particular terms of a document. So even if it's not signed, it would still be deemed as a construction contract made in writing. There are two cases that I'd like to highlight over here. They're both 2016 decisions. The citations are there, but the first decision is Ghazris Sindran Berhad and Hasrat Gemilang. And they held that a contract does not need to be signed by the parties to constitute a contract in writing to be subject to the adjudication scheme under CIPAA. So essentially, Ghazris agreed, or rather basically fortified the position that KLRCA had given through their circular number 03. Now, innovative engineering and nomad engineering is the other case. And in this case, they held that even a simple document like a purchase order although dated prematurely pending execution of a different contract, would still be deemed to be a contract in writing. Even a purchase order unsigned is still contractual in nature, and it would be a contract in writing. You would qualify under Section 2, provided that your project has been done either wholly or partly in Malaysia, and provided that you are not an ordinary lay person, and provided that we are dealing with a property that is not less than 4-story tall, you will be able to pursue a CIPAA adjudication claim. So remember, not everything can go to CIPAA, but because it has been so widely drafted, the definition of construction contract or construction consultancy works, it is probably likely that a lot of things will end up in adjudication if parties choose to pursue such an alternative method of resolving the disputes. Now, the next heading is a little bit subjective, but what I put here is CIPAA is prospective. Now, what is the meaning of prospective is what I will be dealing with in the slides that are coming. Now, CIPAA is prospective is a very famous line that has been, or rather a quote line which has been used very regularly in the construction industry amongst lawyers, because there has been a very drastic change in position as far as how CIPAA scope of application is. Now, the reason for this actually arose as sometime in the end of 2019, in December 2019, there were several cases that had gone before the Federal Court of Malaysia. I have quoted the case here. It is Jekin Pile against Bauer Sendirian Berhad, and another appeal, which is the case of Irika Engineering against PwC. But the facts of Jekin Pile, which is what I will be dealing with first, are as follows. Yep. Now, in Jekin Pile, a construction contract was entered into between a subcontractor and a main contractor in the year 2011. So this is important because the contract was entered into prior to the coming into force of CIPAA. The contract included a conditional payment clause. As you guys would already know, a conditional payment clause is like what I discussed earlier. It's a pay when paid clause or a pay if paid clause. So the fact that the contract included a conditional payment clause, it allowed the respondent, i.e. the main contractor, to withhold payment from the appellant, i.e. the subcontractor, until and unless the main contractor had received the related progress payments from the employer. Now, it wasn't in dispute in this case that the parties had agreed and complied with the mode of payment under the conditional payment clause. Which means that in the year 2008, 2009, the subcontractor had always given respect to the conditional payment clause, because there's an agreement, we have agreed to this in writing, I must comply with it. But then this act came into play only in 2012, which basically voided this particular provision, or had voided the provision of conditional payment clauses, which means that CIPAA had said that conditional payment clauses are now void. But what do you do in a situation like this when the issue is in relation to something that had happened or transpired in the year 2011? So that was what was argued in this case. And in 2016, this matter was decided with by the High Court, and this was what was held. In deciding to enforce the adjudication decision, the court held that the conditional payment clause in the contract, wherein payment would be made by the main contractor to the subcontractor, is conditioned on the respondent having received payment from the employer, was prohibited, which means it is void by virtue of Section 35 of CIPAA. So please bear in mind, the High Court actually said that, look, it doesn't matter that your contract was dated 2011, I mean, it was dated prior to 2012. It doesn't matter, because we have now Section 35 of CIPAA, which has said that this type of clauses can no longer exist. So the High Court relied on actually another case, which is the case of Uda Holdings at Bisraya Construction, which basically held that CIPAA was to be applied retrospectively. So remember, just now we used the word prospective. Here I'm using the word retrospective. And essentially what it means is that CIPAA would apply across the board. It doesn't matter whether your contract was entered 20 years before CIPAA or not, but when when we say CIPAA is retrospective, it means that CIPAA would apply to things beyond 2012. Even if a contract was entered in the year 2005, CIPAA would still apply. That is what it means. That is what the High Court decided in the case of Jackin Pal, and they basically followed the decision of Uda Holdings, uh, which was decided basically a year before Jackin Pal had come up to the High Court. However, when Jackin Pal went up to the Court of Appeal in 2018, this is what the Court of Appeal said. They found that there was no express provision in CIPAA which excluded or which excluded construction contracts made prior to the commencement of CIPAA. So the Court of Appeal affirmed the legal position that unless there was clear words in the act itself, uh, actually stating that it is to apply to apply retrospectively, then we shouldn't just assume that, and we should actually give it a substantive value, which means that the act must be recognized to apply prospectively, which means it should apply to the future and not to the past. It should apply to any contracts entered into after the year 2012, because only then it would be fair. If someone had entered into a contract 5 years before the act had come into place, then surely the conditional payment clause or the pay when paid clause in that contract must be valid. That is what the Court of Appeal had said. And essentially what happened was the federal court affirmed the decision of the Court of Appeal and unanimously ruled that CIPAA operated prospectively, meaning it applies only to future contracts and contracts after the year 2012. It was also further held that CIPAA was a piece of legislation which affected the substantive right of parties, and as it provided an avenue for parties to claim for contractual debts due and owing to them. Now, in the context of Section 35 of CIPAA, as you now know, it is to say that pay when paid clauses are no longer valid. The prohibition on conditional payment clauses it was held that it affected the substantive rights of the parties, and therefore the federal court concluded that Section 35 could not apply retrospectively to deprive parties of their substantive rights. So what happened was, in this case, because it was entered into 2011, the pay when paid clause is actually valid. It is not a void clause because the agreement was pre-CIPAA 2012. So similarly, the same rationale was applied in the case of Irika Engineering against PwC Corp, Sindran Berhad, which was also decided along the same time as Jackin Pal, literally on the same day. Now, since the federal court's ruling on the prospective effect of CIPAA in Jackin Pal and Irika, the courts have readily set aside adjudication decisions, primarily on the ground that the adjudicator has no jurisdiction in law to determine a dispute arising from construction contracts entered into before the enactment of CIPAA. So remember, guys, if it's a 2007, 2009, 2010 agreement that is in question over here, and there is a pay when paid clause in that agreement, then that clause will still be valid and it will still be applicable. However, if it's a 2015 agreement and a 2016 agreement, which has a pay when paid clause, then it would not apply. Or rather, such a clause would be held to be void by the courts or by our adjudication system in Malaysia. So there are already two cases which have fortified or rather have accepted the federal court's position. They are the case of Kiara Fields Sendirian Berhad against Pembinaan Perisai Hebat, and also Bond MNE against Prinsip Tax Sendirian Berhad. So both these decisions have essentially agreed with the position of the federal court. Now, coming to the next heading, what are payment disputes under CIPAA? Now, as you know, payment disputes is the main primary aim of the Act. So what are they actually? Now, a payment, if you look at the left side of the screen, it has been described like this: a payment for work done or services rendered under the express terms of a construction contract. So bear in mind, it is for work done or for services already rendered. It is not for something that you have not yet done. You cannot file a CIPAA adjudication and ask for payment for something that is for the future. It is only for work done or services rendered already. That is what payment has been defined under the Act. Yeah, in respect of work done, this is what CIPA says about work done. It is in respect of work done for the carrying out of construction work or services rendered in relation to the performance of a construction contract. So it could be actual works or could be services rendered, whatever is a type of services, could be supply of materials, could be security services, or anything of that sort. And it must also arise under the express terms of a construction contract, which effectively excludes extra contractual claims such as torts, general damages arising from breach of contract, or a common law claim such as wrongful repudiation of contract. Yeah. So remember, this is the type of things that have to come about. If it's in relation to payment, it must be in relation to a payment that arises under the express terms of the contract. Now, disputes arising from payment, what are they? On the right side of your screen, you would see the type of payment, the types of disputes that arise from payments. These are examples. You have progress payments, which could be either stage, monthly, or stage and milestone payments. It could be final accounts, variations, loss and expense claims, cost adjustments due to price fluctuations, non-release of retention sums, interest on late or non-pay payment, acceleration costs, bonus payments for early completion. Bonus payments, by the way, is something that exists in the construction industry. And if you are interested to know more, there is the case of YTK Engineering against Towards Green. Liquidated damages, of course. These are all the types of disputes that can arise in relation to payment. Yeah, so if you have seen, I've highlighted or rather I've underlined those words as long as they arise under a construction contract and relate to the express terms contained therein. So you can decide, or rather the adjudicator has power to decide on any payment dispute that is referred to him, provided that the payment dispute is related to the construction contract. If it's not related to the construction contract, then he cannot decide on it unless the parties have extended his jurisdiction under section 27, which I had gone through earlier. Now, how exactly does CIPAA work? So this is the workings of CIPAA that I will be going into. And in terms of procedure, what exactly does it entail? Now, CIPAA is actually a two-stage process. Yeah, the statutory adjudication under CIPAA provides for a two-stage process as the payment mechanism is linked to the adjudication regime. Now, what does it mean when I say two-stage process? So there are two stages, which I have called which I would just simply call the first stage and the second stage. The first stage is basically when one party takes the initial steps to actually crystallize a dispute, which means to actually highlight to the other side that, hey, look here, there is a dispute that exists between us. So it is before you actually take any proper action. This is basically just to state that there is a dispute between me and you. That is called the crystallization of a dispute, and that is how the initiation of a CIPAA action would have to start. You have to start with the first stage, which is by filing and serving something known as a payment claim. I will come to that later. But once the first stage is done and dusted with, it could either be resolved by the parties because the party who is being asked to pay money may just decide to pay the entire sum at the first stage. If that is the case, then we do not need to go to the second stage. However, when the dispute crystallize, if you at stage one, you would need to issue, like I said, something known as a payment claim. You would have to serve this on the non-paying party. The non-paying party would then have time to respond to your payment claim through something known as a payment response. In his payment response, he would be allowed to either agree to your entire claim or reject your entire claim, or agree to parts of your claim and reject parts of your claim. So if he has agreed to your entire claim, then there is no need to go to stage two. If he has rejected your entire claim or rejected part of your entire claim, then it is up to you to decide whether you want to go to stage two, which is the initiation of the adjudication itself through the notice of adjudication. So these are the bullet points that basically highlight what I've just said. But to recap, the parties must first exchange their payment claim and payment response. So remember, the payment claim will be issued by the party pursuing the action. Payment response is to be issued by the party who's replying, which means the non-paying party. Of course, there are various manners in which this is to be done, and there are timeframes that are specified under the Act. And once the claim becomes a payment dispute, then the exchanges of an adjudication claim, which we are going into stage two now, yeah, the adjudication claim, an adjudication response, and an adjudication reply. Again, there are specific time frames that are stipulated under CIPAA as to how fast you're required to file these particular documents. But essentially, all of this will be overseen by the adjudicator, who has the duty and obligation to decide on your dispute. And the powers of the adjudicator are also provided under the CIPAA Act. And the adjudicator then is required to determine, of course, if it's in relation to a payment dispute, then he is to determine the value of the payment dispute based on the documents that have been provided to him within a specified period. Again, even everyone is under a very tight timeline. Even the adjudicator only has 45 working days to actually write his adjudication award and decide on the dispute. And this is again something that is stated very expressly under the Act. If you take longer than 45 days to decide, then the entire adjudication basically would be a nullity. Yeah, so Section 37 of the Act is something I would like to highlight to you guys. Uh, it states that the decision, or rather the adjudication decision, is not subject to appeal but has temporary finality. These are the words used under the Act, but has temporary finality, as the CIPAA permits the parties to refer the same dispute to the High Court or an arbitration tribunal prior to, concurrent with, or even after the adjudication proceedings. So this, if you remember in the beginning, I had mentioned that CIPAA is actually sort of an interim dispute resolution mechanism. You are still allowed to pursue the very same dispute through other mechanisms by going to court, by going through arbitration, and so on. It will take much longer, but ultimately, even if you have lost a CIPAA decision, you are allowed to actually challenge the decision, or rather retry the same subject matter by having that same dispute decided in court, for example, or through an arbitration. It may take a lot longer for the court or arbitration to decide on the dispute, but ultimately, if and when the court decides on the dispute, and if the decision of the court is contrary, or rather contradicts the adjudication decision, then basically the court decision or the arbitration decision would sort of supersede the adjudication award. So remember, adjudication itself has temporary finality. While it is final and binding, it is only temporarily final and binding. It can be always subject to a setting aside application, or it could be, set aside by agreement between the parties, or there could be something else that has happened. For example, it has been overruled by a further court proceedings or an arbitration proceedings, which was filed at a later date after the adjudication award. Now, payment claim and payment response, what are they? Yep. So payment claim, the adjudication process, firstly, as I've mentioned, commences, the starting point is this, yeah? It starts with the service of a payment claim by the unpaid party on the non-paying party to the particular construction contract. So Section 5 is what deals with the payment claim, and it states that the payment claim must be in writing, and it has to include the following requirements. Firstly, the amount claimed and the due date for payment of the amount claimed. For example, if it's in relation to uncertified progress payments, then what are you saying? How much exactly is owed to you, and when was these payments due to you? Was it 30 days from the date of the progress payment? Or so on. So you detail down all of this, you identify the cause of your action, you include the provisions in the construction contract, and you highlight those provisions to which you are actually talking about in relation to the payment dispute. You may also describe the work or services to which the payment relates. All of these are essential things that should be in your payment claim. Now, the payment response is something that the unpaid party would have to actually file. Section 6 is what deals with payment responses, and Section 6 states that upon receipt of the payment claim, the non-paying party must issue a written payment response within 10 working days, either to admit the payment claim together with the whole amount claimed, or any amount as admitted, or to dispute the amount claimed in the payment claim either wholly or partly, stating the amount disputed and its reasons. So this is what the unpaid party would have to do, but there is something else that I need to highlight, which is very important. Section 6, subsection 4 states that if the payment response is issued in a manner not prescribed by CIPAA, or if it is not issued at all, please remember this, or if it is not issued at all, then the non-paying party is deemed to have disputed the entire claim. So this is actually very odd because one would think that if someone doesn't file a payment response within the 10 working day period, then actually it should rightfully mean that he has sort of nothing to say to the payment claim. He has got uh, nothing to deny on in regards to the payment claim, which means he should be deemed to accept everything. But that is not the position. It says that Section 6.4 states that if you don't file your payment response, then it doesn't really matter. It actually means that you're disputing the entire payment claim. So some parties, what they do is, the unpaid party, sorry, the non-paying party, what they do is, once they receive the payment claim, they will just keep quiet. They will not file a payment response because essentially not filing a payment response means or is equivalent to denying your entire claim, denying the entire payment claim that has been filed by the unpaid party. So when that happens, this is what we call the crystallization of a dispute happens, which means that the responding party has already said that they are denying everything through the non-filing of the payment response, or even if they file the payment response, sometimes they would say that we only agreed to pay 5,000 for this particular certificate, everything else is disputed. So that is the way in which a dispute crystallizes. And when a dispute crystallizes, we move on to referring the matter to adjudication, which is when the AIAC comes in, or which is when the actual process starts under the adjudication scheme. So that is my next part, which is commencing the adjudication process. So a party can refer the dispute that arises from the payment claim to adjudication under Section 7, subsection 2 of the Act. Now, it states that either party, be it the unpaid party or non-paying party, either one of them actually have the right to refer the dispute arising from the payment claim to the adjudication process. Now, of course, this right can only be exercised after the period to serve a payment response has expired. Of course, the fact that either party has access to statutory adjudication, that itself, I think, is commendable, because if you think about it, naturally one would think that it's only for the claimant to pursue this, which means the non-paying, or rather the non-paying party would actually file this action, but it's not the case. Both sides, non-paying party or the unpaid party, would be allowed to actually refer the matter to adjudication. So an employer also is able to actually file an adjudication to seek to recover costs from, for example, engaging a third-party contractor to remedy defects caused by and fail to be remedied by the earlier contractor. You can also refer those type of disputes to an adjudication. So Section 8, subsection 1 of the Act deals with how the notice is to be drafted. It is called a notice of adjudication, and it is to initiate proceedings. A notice must first be issued by the claimant to the respondent. The notice must include, again, the nature and description of the dispute, just like how your payment claim would have done, and the remedy sought by the claimant together with any supporting documentation. So please always remember, when you're moving on to the next stage, you must actually put in your supporting documents, certificates, progress payment claims, proof of communication, or whatever there is to actually support your position. So once the initiation of adjudication is done, the notice of, which is through the filing of a notice of adjudication, the adjudication comes to life. Once the notice, yeah. So when I say it comes to life, what it means is they have to move to the next step, which is appointing an adjudicator. So the crystallization of the dispute has already occurred. Once the notice of adjudication has been referred to AIAC, the next step would be for the appointment of an appointment of an adjudicator to decide on your dispute. Now, appointing an adjudicator can be done in two ways. Firstly, the issuance of the notice of adjudication itself automatically triggers here the process of appointing the adjudicator, who will then have to decide on the dispute. But how is this done? You would think, one would ask. So there are two ways in which it can be done. First is by agreement between the parties. So if the two parties in the adjudication decide that they want to appoint Mr. X or Mr. Y as the adjudicator on their dispute, then you are entitled to do so. But you have to actually write, or rather inform the adjudication body, our AIAC, within 10 working days from the service of the notice of adjudication by the claimant on the respondent. So if you receive the notice of adjudication today, then you and the other side have got 10 days to actually agree on a particular adjudicator. If you cannot agree on a particular adjudicator, which is what happens most times, then it would by default fall to the director of AIAC to actually appoint an adjudicator, a neutral adjudicator on your behalf. And he has to do this within 5 working days upon receipt of the request of either party in the dispute. Yeah, so if parties fail to agree on the identity of the adjudicator within 10 working days, then you would move to the next step, which is one party writing to the director of AIAC saying that, look, we have tried for 10 working days to appoint an adjudicator that is common to us. We cannot agree. So please proceed, Mr. Director, to appoint an adjudicator to decide on this. So he will then have 5 working days to appoint that person. And once that is done, you will move to the next stage, which is once the director has appointed the adjudicator, again, either party may be allowed to object to the validity of the adjudicator's appointment, but please bear in mind that this must be made during the adjudication proceedings and not at a later stage. There's interestingly a case of which was decided in 2017, Zana Bina against Cosmic Master Development, which said that a party who participated fully in an adjudication without raising any objection to the adjudicator's appointment would be stopped from raising this objection later on. So if the director of AIAC has now suggested Mr. A to be your adjudicator, you are still allowed at the very stage to say, no, I don't want Mr. A because Mr. A is actually a family member to the respondent, for instance. But you cannot actually do this after the whole process has ended. So once both sides have agreed to a particular adjudicator, which has been proposed by the director of AIAC, then the whole process starts, which is the filing of the adjudication claim, the adjudication response, and the adjudication reply, which is similar to how our court pleadings work: statement of claim, defense, and your reply to defense, which is the topic that I have you're seeing on your screen right now. There is the added thing of the adjudication decision, which I will deal with over here. So section 9, subsection 1 is the section which states that upon receipt of the acceptance of appointment from the adjudicator, the claimant has 10 days to issue the adjudication claim to the respondent. So please bear in mind when I say 10 days over here, it means 10 days in the particular area where the project is being conducted. Maybe you will understand this more when I come to section 10. Section 10 states that the respondent has 10 working days to submit their response upon receipt of the adjudication application from the claimant. So 10 working days, again, this is where I want to emphasize my point. It means 10 working days uh, in the site, or rather on the site which is in question. So for example, if your project is in Terengganu or Johor, then please bear in mind that your working days would be Sunday to Thursday. So it would be different if you're in Kuala Lumpur. So different states have got different interpretation when it comes to working days. Section 11 states that the claimant has 5 working days upon receipt of the response to submit a reply to whatever is stated in the adjudication response. And ultimately, under section 12 of the Act, the adjudicator has got 45 working days from the service of the adjudication response or reply, whichever is later, to make a decision on the dispute. So as you can see, it all happens very fast: 10 days, 10 days, 5 days, and 45 days. Some of it are working days, please bear in mind. So remember, when it comes to working days, it has to be working days as defined in the locality of the location. So once the adjudication decision has been made or an award has been rendered, we move to the next step, which is what do you do with the adjudication decision? How do I actually get the money from the losing party? So Section 28(1) of the CIPAA Act actually deals with this, and it states that in order to enforce a decision, a successful party may apply to the High Court for an order to enforce the adjudication decision as if it is a High Court judgment, or sorry, it is as if it is a judgment or order of the High Court. Now, what this means is that you can actually apply to the High Court under Section 28 if you have an adjudication award decided in your favor. All you have to do is apply to the High Court under Section 28 saying that I have an adjudication decision. Can I please apply to have this adjudication decision as if it is a judgment or order of the High Court? The High Court can then grant you that order, and once you have that, you are allowed to proceed with executing the High Court judgment in any way that you wish to do, which is either through garnishee proceedings, either through a writ of seizure and sale, either through winding up. All of these are methods of execution that would be available to a person who, or to a party who has actually registered the decision in the High Court. So that is the power of an adjudication decision. Yeah, it is quite powerful because you can actually enforce the adjudication decision as though it is actually an award of the High Court. So although just now I have said that an adjudication decision is interim in nature, meaning although it's final and binding, it is only final and binding for a temporary period. It could always very well be set aside by a separate proceeding of a High Court or a separate arbitration, which is going on concurrently. Ultimately, it is still a very, very powerful tool because Section 28 would still mean that a party who has an adjudication award is allowed to actually enforce this way. And if the losing party has not stayed the adjudication award or has not managed to set aside the adjudication award, then it's going to be very difficult to actually sustain his fight on the case. Now, the case of Subang Sky Park and Arcadia Sendirian Berhad is a 2015 decision. And basically, it held that Section 28 provides the correct avenue for successful parties in adjudication to enforce their decision. And Subang Sky Park had also actually commented on a very powerful provision of the Act, which is Section 29. Section 29 states that when a party has won an adjudication, the winning party can choose to do this. He can choose to exercise the right to suspend or reduce the rate of progress of performance on the project. But you cannot just simply do that, meaning just because an adjudication award decision has been made, you do not automatically qualify under Section 29. You have to do a few things under Section 29. First is a notice of intention must be issued to the other side, telling them that, look here, if you do not pay me the adjudication award within the next 14 days, then I have the right to actually reduce the rate of progress of my performance or to actually suspend my works completely, which means I'm not going to do any work. I'm not going to come to the site at all if you don't pay me my money as decided in the adjudication award. So it's very, very powerful because what happens now, what it means is that a losing party almost has got no choice, especially if you are the employer or the developer, but to actually pay the disputed amount first, or rather, sorry, pay the adjudicated amount first. Because if you don't do that, then the other side has a chance to actually issue this notice of intention to reduce their rate of progress of performance, which isn't so bad, but they can further reduce to actually just, so not reduce, they can actually suspend their entire works altogether, which means they can just choose to not show up to work if you choose not to pay them. Section 30, on the other hand, is another very useful form of enforcement as well. And this is what Section 30 states. If the winning party is a subcontractor, then the winning party also has the option to make a written request directly to the principal of the losing party to pay the adjudicated amount. So Section 30 is basically very powerful because the subcontractor now can actually try and claim monies from the principal of the losing party. So even if the losing party doesn't pay him the money or doesn't pay the adjudicated sum money to the winning party, if he's a subcontractor, he can straight away go to the principal and say, "Look, Mr. Principal, your main contractor has lost an award to me, or rather has gone through an adjudication proceedings, and in that adjudication it has been decided that the main contractor owes me, say, 100,000 ringgit. You now, as the principal, please pay me the adjudicated sum." So it's very powerful because you can actually even go after the principal under section 30 to ask for monies to be paid directly from the principal directly to you on behalf of the main contractor. So essentially the principal is paying for the main contractor, yeah. And this was actually illustrated in the case of Murni Environmental Engineering against Eminent Ventures. Yeah, so what it stated was that the principal is obliged to make payment to the party with a favorable adjudication decision against their contractor, regardless of the fact that they are not aware of or a party to the adjudication proceedings. But there is one added requirement over here under Section 30. You cannot just simply claim from the employer. Uh, there is the important thing that needs to be in existence is that the employer actually owes money to the main contractor. If the employer owes money to the main contractor, only then can you apply under Section 30 to the employer asking for payment under Section 30. If there's no payments due between the employer and the main contractor, then unfortunately Section 30 may not be a best method of moving forward with the adjudication decision. Section 13, I keep emphasizing on this. I've already mentioned it a few times, but now this is the provision which actually states it itself. The decision made by the adjudicator will be binding on the parties until and unless it is set aside by the High Court on any of the grounds listed under Section 15. The payment dispute is finally settled by agreement in writing between the parties, or the dispute is ruled on by the arbitrator or the court. So yeah, this is the exact wordings of Section 13, essentially uh, emphasizing what I have been saying all along, that adjudication is really sort of interim in nature. Although they say it's final and binding, it is only temporarily final and binding. If any of these things were to happen, then the adjudication award would simply cease to exist or will no longer be something that you would be able to use anymore. Now, Section 15 is the grounds under which you're allowed to apply to set aside an adjudication decision or an adjudication award, as you may call it. But what circumstances under which you would have to qualify to be able to actually apply to set aside an adjudication decision? I can say this quite confidently. It is not easy to succeed in a setting aside application of an adjudication award because the grounds for which you would be successful are very difficult to prove. First, the type of the limited grounds that fall under Section 15 would be that the decision was obtained improperly through fraud or bribery, that there has been a denial of natural justice. I'll come to that in a bit. What is natural justice? Or the adjudicator has not acted independently or impartially, or the adjudicator has acted in excess of their jurisdiction. So as you can see, there are very high hurdles to pass uh, in a setting aside application to the High Court. So I'm now moving towards towards the last 10 minutes of this session. I will now just review a few recent court decisions which deal with this 4 points you've seen on your screen: natural justice, winding up pursuant to an adjudication award, enforcement denied if there is a court judgment, and termination of contract and final claims. Yeah, so the two principles of natural justice, yeah, is very simply put in a layman's words, it would be it's the rule against bias and the right to be heard. So if a party has got denial of this type of rights, meaning he feels that the adjudicator was biased towards him, or he feels that the adjudicator did not give him chance to be heard, then he can be said to be have been denied of his rights to natural justice. That is what essentially natural justice means. And there's one case that I want to highlight here. highlight here, which is the case of the Saru Peace Holdings against Malaysian Resources Corporation Berhad, 2019 decision. In this case, the adjudicator had limited the adjudication reply to 10 pages, which was fine. But an objection was raised by the respondent when the claimant exceeded the 10-page limit. The adjudicator allowed the adjudication reply in its entirety on the ground that the claimant ought to be given the opportunity to be heard. Unfortunately, the adjudication decision was set aside for breach of natural justice, as the adjudicator was found to be biased and acted in favor of one party by allowing only one party to the proceedings to not comply with the procedural rules he had set, and ignoring the objections of the other party to the proceedings. So this case, of course, serves as a useful pointer to adjudicators to uphold all rules of natural justice in safeguarding their decisions against a challenge for breach of the principles of natural justice. So as you can see here, the adjudicator basically made a rule to say that you cannot, both sides not to exceed 10 pages. One side complies with it, one side doesn't comply with it. The adjudicator tells, never mind, it's okay, although you have not complied with it, I am willing to accept it. So it has been concluded in this case that that was unfair. The adjudicator, if he had given face to the other side to exceed 10 pages, then the same opportunity should have been granted to the other party as well. The rules should be the same for both sides. Essentially, it should be a level playing field. That is what uh, the rule against bias or the principles of natural justice essentially mean. The right to be heard simply means the fair opportunity to present evidence and arguments before a tribunal makes its decision. Another case where has come about as relevant is the case of Guangzi Dev and Cap Sindran Berhad against Sikal Berhad, which is a decision in 2019, which basically held that there was a violation of the principles of natural justice when the adjudicator rejected the appellant's application to call three expert witnesses, as that had deprived the appellant an opportunity to present a complete defense. So, as an adjudicator, you should actually give both sides ample opportunity to present their cases. Do not try and take shortcuts. Do not try and make rules which are going to sort of deny a party its chance to actually put forth its entire case. Because if you do that, you would be actually creating an award which is very likely susceptible to a breach of natural justice, which means that the losing party would have a very easy or simple task to set it aside under Section 15 of CIPAA Act by applying to the High Court. Now, the next case that I would like to highlight is the case of Likas Bay Precinct against Binapuri Sendran Berhad. Now, Likas Bay is a decision of the Court of Appeal, and it held that it is not a mandatory requirement for an adjudication decision to be registered with the High Court pursuant to Section 28 for the purposes of issuing a notice to wind up a company under the Companies Act 2016. Now, in arriving at this decision, the Court of Appeal held that the language in Section 28 of CIPAA does not in any way convey that a decision of the adjudicator must be registered with the High Court before a statutory notice under paragraphs E and H of subsection 465 of the Companies Act, which are winding up provisions, could be issued. So essentially, they said that a creditor who is not paid money, has a right to file a petition to wind up the debtor company. It's as simple as that. The court took the view that Section 31 of the Act, which states that remedies provided by CIPAA without prejudice to other remedies available in the construction contract or any written law, can be invoked by a successful party. So this is again a decision which has actually brought about a lot of attention in the legal sector, because now what has happened is a party who has an adjudication award decided in his favor would not even actually have to register it under Section 28 of CIPAA first before applying to wind up. He can immediately, upon issuance of the arbitration award in his favor, file a winding up notice, or rather issue a notice to wind up the company. And within 21 days, if there's no response to the notice, he would be allowed to actually file his winding up petition itself. So again, it's a very powerful decision, I would say, because it again tells you how powerful an adjudication award is and what can happen to a party who doesn't comply with an adjudication award.
Yeah. The next case is the case of Prestige Mega Construction against Keller and others. Sorry, against Keller Sindran Berhad and other cases. Now, this case, it was held that the application to enforce the adjudication is in what happened here was the adjudication decision, or rather the application to enforce the adjudication decision, it was dismissed by the court because they found that there was already a court judgment, which was a judgment in default on the same disputed amount. So the courts held that the judgment, which was a judgment in default, was held to be the final determination of the dispute between the parties in accordance with Section 13 of CIPAA. So the basically or rather the arbitration decision on the same dispute could not go on, basically because there was already a high court order, or rather a high court decision which sort of supersedes your adjudication because it's in relation to the exact same dispute. So an enforcement can be denied if there is already a court judgment in respect of the same subject matter. Termination of contract and final claims. How does it work? This is a case that I had just touched on earlier, the Martego and Architect Mio. The case had gone all the way up to the federal court. And in this case, what happened was the respondent, which is a firm of architects, had resorted to bringing an action under CIPAA against the appellant to recover its professional fees for works and services rendered to the appellant. At the time the payment claim was served by the respondent, the construction contract between the parties had been terminated. So please bear in mind that when the payment claim was served, the construction contract no longer existed. It had been terminated. The adjudication decision was delivered in favor of the respondent, was challenged by the appellant. And the appellant, what they argued was that the contract, because the contract had been terminated, there was no longer a construction contract for the purposes of CIPAA. And hence, the dispute arising from the terminated contract was not cannot be subjected to CIPAA because technically the construction contract no longer exists. It ceases to exist as a result of the termination. A very clever argument, I would say, but unfortunately, on the facts, the federal court found that the construction contract between the appellant and the respondent expressly contemplates payments made after the said contract has been terminated. So the federal court held that the absence of such a provision does not deprive a party of its entitlement to make a payment claim after the construction contract has been terminated. What this means is even if a contract has been terminated, even if it's in relation to a final claim payment, you are allowed to actually still go through the adjudication process. Uh, the federal court also discussed the issue as to whether CIPAA ought to apply to interim or final claims only, given that the appellant had argued that CIPAA ought not to cover claims for final accounts or sums finally due to the unpaid party. So again, this was a clever attempt by the non-paying party to state that it should not cover claims that are final accounts. If you want to decide on final accounts, then you have to go to arbitration or court or whatever it is. That is the argument that they had taken. But unfortunately, again, for them, the federal court decided that this is not logical. Uh, CIPAA must apply to final accounts as well as all other types of claims. As long as they are payment claims, they are allowed to be subjected to CIPAA adjudication. And as long as they are, even if they are terminated contracts, they would still be subjected to CIPAA. So as it has been defined in Section 4, CIPAA may come into play regardless whether the payment claims were interim or final claims after termination. So this is again provided also in the Act itself under Section 4. So this brings me to my closing remarks. In my conclusion, although statutory adjudication under CIPAA has only been in operation since 2014, which means it's only been 7 years. There's been considerable growth in the number of adjudications that have been filed in Malaysia. We've seen an increased growth in the number of cases every year since the year 2014. Subject maybe to the 2020 statistics. We don't have that yet. There's probably a decline in the number of adjudication cases for 2020, but that's probably because of the pandemic. But suffice to say, public has got confidence in the statutory adjudication scheme. We are seeing a lot more adjudications come about, and this is indeed alternative dispute resolution method, which is being in terms of much higher preference in the construction industry in Malaysia. So we're also fortunate because we have specialist and supportive courts, which are systems ready to deal with this kind of issues. They are the right forum to enforce adjudication decisions. And please bear in mind that the courts have been very cautious in setting aside adjudication decisions, or even for that matter, to stay or adjudication decisions to basically prevent parties from abusing their rights under Section 15 and 16 of CIPAA, and to uphold the Parliament's intention to provide a speedy mechanism. Again, the emphasis is speedy mechanism to resolve construction disputes with temporary finality. So that being said, I will wrap up this session and I will hand it back to the host or to any of you who may have any questions for me. Thank you very much.
Thank you, Mr. Angki, for the enlightening sharing. I'm sure it is very helpful to many, especially our attendees today. So if anyone who have any other Q&A, any question, you can just post it in the chat box here. But I've seen a few questions posted here. So I will read it out first. So the first question will be from Wei Xin. So the question is, what if there is no contract in writing, but there's other evidences, for example, progressive claim, proof of payment, etc., to prove that there is actually such contract between the parties? Can this be covered under the CIPAA Act? Dia tak ada. Mr. Ankit, I think you are still muted.
My apologies for that. So sorry. Wei Xin, yeah, thanks for that question. Very good question. Yes, my answer would be such a thing, or rather such type of evidences would in fact be construed to be a contract in writing, because our courts have already decided that even when it comes to evidence of communications or even unsigned agreements would be deemed to be a construction contract in writing for the purposes of the definition. So yes, I would think if you have evidence, for example, progressive claim, proof of payments, to prove that there is, some communication between them, that would actually be sufficient to be covered under CIPAA.
Okay, thank you, Mr. Ankit. So I hope that answered Wei Xin's question. So now we come to the next question from Ms. Tiffany Go. The question is, can we counterclaim against the claimant for a sum which is more than the claim?
Well, okay, so you can do that, but usually it is not done because, for example, the payment claim is, say, for 50,000 ringgit. You may say that, hey, yes, I owe you 50,000, but there are defective works which we told you to rectify. You didn't rectify. I had to call in a third-party contractor. As a result, now I've spent another 100,000. Therefore, actually, you owe me 50,000 ringgit. You can do that. That is why, if you have seen that in the Section 7 of the Act, it says that either party may bring the dispute, refer the dispute to adjudication, be it the payment, be it the unpaid party or the non-paying party. So you can do that, but it is always more advisable to actually pursue a separate action. I would suggest that, which is more than the claim. So to allow it to be decided by perhaps different adjudicators. And I would suggest this because it actually gives you a better chance, and it doesn't seem like you are trying to not pay because of of certain other things or whatever. So it is usually a strategical decision, those kind of things. The next question, please. I hope I've answered your question, Tiffany.
Okay, thank you, Mr. Ankit. So right now, we still have a few more other questions from Ms. Tiffany Go. So I will just read all her questions here, posted here. So the first one will be, we have a scenario here where we refuse to release the retention sum because the SO has yet to issue the CMGD. So the LP has expired since 2020, as apparently the main con has yet to complete rectifications. If the main con claims against us via CIPAA, we will need the main con to also agree if we wish to seek for the adjudicator to determine issues relating to the main con, not in compliance with the architect's cert, by referring to section 27.2.
Sorry, just give me a second. Yeah, we will need the
Yeah, sure.
That is correct, Tiffany. Again, yes, you will, because there are issues that are beyond if it's beyond what is payments structures that are in the construction thing, then you must actually agree in writing to decide on matters beyond that. So yes, that would be correct. Naturally, it would be only payment disputes under the construction contract. If you want to expand the jurisdiction of the adjudicator, then you are allowed to do that, but it can only be done if both parties agree to it under section 27, subsection 2.
All right, thank you, Mr. Ankit. So I come to the next question here by Ms. Tiffany as well. So the next question is, if the developer is being claimed by the owners for defects rectification, and the defects are due to the non-compliance of AI by the main con, can we write to the main con attaching all invoices showing the costs and expenses incurred in rectifying the defects and to set off from the retention sum directly without the main con's consent?
Okay, so this is not this is actually not a CIPAA related question, I would think, because right, am I correct to get understand that, Tiffany? This is just a general question. If the developer is being claimed by the owners for defects, and the defects are due to non-compliance of architect's instructions by the main con, can we write to the main con, attach all invoices showing the costs and expenses incurred in rectifying the defects, and to set off from the retention sum directly without the main con's consent? Okay, that is okay. So this is not like I said, it's not a CIPAA question. It would really depend on what your contract is. If it's a PAM contract, then please look at the relevant provisions on setting off. Please look at the time provisions on whether you would be required to give any notice to them. Usually, like I said, even when it comes to rectifying works, you would actually, if it's under a particular, if it's under defect liability period time, then you actually are supposed to give notice to the other side to rectify the defects. Once they rectify the defects, if it's satisfactory to you, then the CMGD would be issued. So I'm not sure what your full facts here are, but it would really ultimately depend on what stage you are at. You can actually apply to set off the sums from the retention sum, provided that you have actually given a chance to the other side, rather to the contractor, to rectify the defects. He has failed to rectify the defects within the stipulated period of time, and you have then decided to engage a third party who has now rectified the defects, and you have also given them notice that they would be liable for all costs and expenses that are to be effected, that are going to be charged on you by the third party contractor. So if you have all of that in order, then yes, I would say that it is advisable to actually just finally write to them to say that we are going to set this off from the retention sums directly. You would be in a better position. If you do that without doing any of the steps that I've mentioned, then in all likeliness, the main contractor will probably challenge it, or will probably file an action against you to recover the retention sum. Thanks.
All right, thank you, Mr. Ankit. So the next question here is, can a main con claim against the subcon and developer or principal in a single CIPAA action?
Sorry, I'm trying to look. Can a main con, sorry, I'm looking at the chat as well. So it sometimes runs because more questions are coming. Can a main con claim against the subcon and the developer principal in a single CIPAA action? You mean whether you can do it simultaneously? Yes, you can, but of course you wouldn't be able to recover more money than what you have been adjudicated. So what you can do is you can apply under section 30, whoever has lost the adjudication, you can ask them to pay you the money. If he is unable to pay you the money, if that main contractor is unable to pay you the money, then you as the subcontractor, you are allowed to actually even ask the principal for the money. How they pay you, whether they pay you 50%, 50% or 80%, 20%, doesn't matter. But ultimately, you are allowed to do it simultaneously. Yes.
All right, thank you, Mr. Ankit. So the next question here is, if non-release of retention sum was due to non-issuance of CMGD, will the main con take action against the SO as well?
That would really, I think, depend on who is advising the contractor. But if I was the contractor, and rather if I'm advising the contractor, first things that I would inquire is there any reason or are there any suspicions that you feel that the SO is perhaps in collaboration or in cahoots with the employer? Do you think that the SO is not issuing the CMGD for valid reasons, or is he just merely following blindly the instructions of the employer like a parrot? So depending on what your facts are, you will have to decide whether you want to take action against the SO as well, or you just want to take action against the employer. So yeah, it depends on the conduct of the SO in the circumstances or in the facts of whatever you are dealing with.
Okay, all right, thank you. So the next question here is, if the name of the claimant A is different from the name of the main con in the construction contract AB, can we raise objection and dispute the entire claim, provided that there were correspondences showing discussion of the construction issues between the developer and AB? Does it amount to recognition of AB?
Wow, interesting question. Arguable, definitely. It is arguable, but ultimately, it would really depend on the evidence that is presented. If they can show, or if the lawyers are able to demonstrate that there is a connection between A and AB, or rather, if A and AB is the same thing, or rather, if AB was merely a name change of A, and it is for all intents and purposes the same party, then the adjudicator or the arbitrator or the judge, whoever it may be, would have to look at the facts presented to him objectively and decide whether or not there is actually merit in the contention made by the objecting party, that there is actually, these are two different parties altogether, and this should not it does not amount to recognition by one party just because the other has done it. It would really ultimately depends on the facts presented before the tribunal. Thanks.
All right, thank you, Mr. Ankit. So it comes to our last question here from Yvonne. So her question is, can a subcon claim against the main con and developer or principal in a single CIPAA action?
Yeah, that is, I think it's a repeat question, I believe. Can a subcon claim against the main con and developer? Yes, they can. As I've said, they are allowed to actually claim against the main con, or rather claim against, yeah, you would of course claim against the main con. You would not claim against the principal. Like I said, only after you have got the adjudication award, you can actually ask the principal to pay the money that the main con hasn't paid you. But you do not usually, the subcon doesn't usually file an action against the principal because there's no privity of contract with the principal. The subcon would have a contract with the main contractor, and the main contractor in turn would have a separate contract with the principal. So it is very rare that the subcon files an action against both the main contractor and developer. What the subcon usually would do is file an action against only the main contractor. Once he gets the award in his favor, he can then actually attempt to claim the money from either the main con or even the developer, directly from the developer under section 30, which is payment from principal, provided that there are sums due and owing from the developer to the main contractor.
Okay, thank
That,
you, Mr.
yeah.
Ankit. Thank you, Mr. Ankit, for answering all the questions posted here. So if there's no more question, you all can just scan this QR code to give feedback on our session today.
Yep, thank you.
Okay. Mr. Ankit, can you please show the feedback QR? Yeah, thank you. All right, so dear participants, our next session is assessment session. Please scan this QR code for the questions and please submit your answer within 10 minutes. So I believe that's all the time we have today. This marks the end of our webinar for today. Thank you very much for joining us today.
Thank you, everyone. Thanks for tuning in, and hope everyone had a good session. Till the next time. Thank you. Bye.
Thank you, Mr. Ankit.